I'm Gary Tabakman. I'm a Houston criminal defense attorney. Today I want to talk to you about considering filing a motion for a new trial and the top 10 reasons as to why you should file a motion for a new trial post-conviction after you have gone to trial. Most people do not understand that filing a motion for a new trial is an essential vehicle to assist you with your appeal. I have handled dozens of motions for a new trial, and I can tell you that the success rate on a motion for a new trial can absolutely be the thing that you need in order to be able to get your case back in front of a court or to bolster your appeal in order to give you much better chances on an appeal. The top 10 reasons as to why you may want to consider hiring someone for a motion for a new trial, starting with number 1, is newly discovered evidence. When you go through trial, all of a sudden, you realize that there was so much evidence that was developed and so many things that your lawyer may have not considered that you need to look somewhere else. You have only 30 days. It's a very small window, and you have to do this quickly. So one of the things that you need to consider is hire a lawyer right away, have that lawyer hire an investigator, run down any and all leads which may potentially lead to new evidence. This new evidence can be put into a motion for a new trial for that same trial judge or an associate judge here in Harris County to consider what evidence should have been considered and may have been important to your case, which may have concluded in a different outcome. The number 2 reason that you want to file a motion for a new trial is to consider any ineffective assistance of counsel claims. This is probably the number 1 reason as to why someone files a motion for a new trial. Otherwise, on appeal, you cannot complain about the performance level of your counsel. That being the case, whether or not your lawyer did not perform up to par prior to trial, leading up to trial with the investigation phase, leading up to trial, preparing for trial, during trial, or even in some cases right after trial and how they have advised you in the things that you should do after trial. You need to be able to hire a lawyer that understands what ineffective assistance of counsel claims can be made, which would be considered as constitutional violations, which is your right in order to be able to bring to the court's attention issues that may have come up that could, again, give you a better chance of reopening your case right away or bolstering your case on appeal. In the event that you filed a motion for new trial with an ineffective assistance of counsel claim, all of that information gets put into the record and goes up to the Court of Appeals for the Court of Appeals to then break down and consider any and all arguments that you have made before the trial court, especially in hopes of the fact that you've received an evidentiary hearing at the court below that has developed the record even more so with information that could be helpful for the court to consider moving forward on appeal. The number 3 reason you want to file a motion for a new trial is potential jury misconduct. What a lot of people do not know is that there are issues that occur not frequently but seldomly when a jury goes back into the jury room and starts to deliberate. I have seen cases, and I have been a part of cases, where jurors are deliberating in the back and all of a sudden you have 2 or 3 jurors that are so imposing on other jurors that they start to convince people that the only way that they're leaving there is if you vote a particular way. That is completely inappropriate. So oftentimes what happens in circumstances like that, and if we find out or if there's any potential issue that comes up like that to our attention, which usually comes from a particular juror that participated in a trial, we hire an investigator to go talk to all the jurors that participated in that trial, and those jurors are hopefully going to come forward and give you a fair and honest affidavit or fair and honest interview that will provide the ability to make a claim on a motion for a new trial, which gets your foot in the door as quickly as possible in order to attempt to reopen the case. The number 4 reason would be prosecutorial misconduct. Obviously, this is not something that happens frequently. However, there are occasional rogue prosecutors that take it upon themselves to do things that's outside of the norm or outside of what we would consider to be professional. Professional conduct within the space of what we do as officers of the court is everything to the system. It's everything that we do as far as why we became lawyers and why we treat this profession with such seriousness and such love for what we do. In the event that there is a prosecutor that took it upon themselves in order to hide evidence from a defense attorney that would have potentially been exculpatory, or that prosecutor has manufactured evidence that was not accurate or has spun something in a way to where it's completely inaccurate in order to get the result that they're seeking. That is something that we could bring to the court's attention in a motion for new trial. A prosecutor's job is to seek justice. A prosecutor's job is not to represent victims. A prosecutor's job is to represent the state, and it's to present facts to the jury and to judges that can ultimately give jurors the ability to decide whether or not somebody committed a crime beyond a reasonable doubt. If a prosecutor oversteps that boundary, it's our job as lawyers to be able to find it and to help you seek the relief that you need in a motion for new trial, and in order to be able to, again, bolster the record in order for the Court of Appeals to consider whether or not this actually occurred and it impacted your case in the event that the judge has not agreed to reopen your case through a motion for new trial. Number 5 reason may be improper jury instructions. I've had cases reversed on appeal for improper jury instructions. The instructions to a jury is what a trial judge reads out to the jury for considering whether or not there was enough evidence that was brought to the juror's attention to consider a guilty verdict or a not guilty verdict if there was not enough reasonable doubt developed. The jury charge is the essential form and document that encompasses all of the elements that are required for a jury to consider how the jury should proceed. Misinformation within the jury charge or information that is added that should not be there can have influenced a jury to have voted a guilty verdict as opposed to considering a not guilty verdict, which could have heavily impacted the jury's ability to properly deliberate in your case. If that is found, it is an automatic opening for the consideration of a judge to be able to reopen your case through a motion for new trial. And if not, at the very least, you have, again, bolstered the law to such a degree to where the Court of Appeals has much more to consider with respect to how legally your case should be considered to be reversed on appeal. The number 6 reason why you may want to consider filing a motion for new trial is legal error by a judge. Obviously, judges are human beings. They're not perfect. There's some really good judges. There are some judges that are just not anywhere near experienced enough in order to be able to call balls and strikes within a courtroom and make certain decisions in the way that they should have been made. These errors can encompass many different things. It could be legal rulings that were made in forms of objections. It could have been rulings that the court had made based on the law that was presented to them and they decided to go in a different route. It could also be matters that revolve around timing. It could be matters that revolve around how a judge ultimately makes a decision with respect to which witnesses testify, which witnesses don't testify, the types of witness testimony that's elicited, and much of it surrounds whether or not evidence that came in was prejudicial toward you as a defendant in a case. In the event that we're able to develop enough evidence regarding this situation, we can bring that into a motion for new trial. This would require for you to, however, hire a lawyer very quickly on a motion for new trial because we have a very small window within that 30 days in order to develop all of that information that is necessary for us to bring that to the court's attention. The number 7 reason that you may want to consider as to why you should hire a lawyer to file a motion for new trial is that the verdict is against the weight of the evidence. The jury's verdict has to align with the evidence that was presented. There could be sufficiency issues with respect to what the evidence showed, what evidence was brought forward, and what evidence the jury did or did not consider. This is a rare issue, albeit it is an issue that it can go into a motion for new trial, which should be part of your consideration efforts as to why you should hire someone. The number 8 reason is new forensic and scientific developments. This is a rare issue, however, one that can be developed as long as you get ahead of it. There are times whenever we have seen either DNA issues or issues with respect to forensics such as fingerprints and identification issues that can be helped to get you into a place to where the court can consider reopening your case right away and also give you the ability to, again, bolster the record for appeal in order to make your appeal that much stronger. The number 9 reason is witness recantation. I have been a part of cases where this has happened as well, where there are multiple witnesses, for example. One may be an eyewitness to a crime, another may be an eyewitness that has overheard of a crime occurring. Individuals that come forward that say that this actually never happened is absolutely a massive reason to be able to give you another chance and to bring that to the court's attention in order for you to get another shot. This is obviously a very important development in any case. If it happens, it gives you the best possible chance in order to get you back into the courtroom. And if you overhear any sort of issues that may have revolved around a witness being able to come to the table in order to express themselves in that way, you should definitely bring that to a lawyer's attention as soon as possible that can help you file that motion for a new trial. And again, bolster your record for appeal. Number 10 reason is obviously, as we've been talking about, is preserving all issues for appeal, just in general. And I want to talk to you a little bit more about this. What most people don't understand and what most people don't know is that a motion for a new trial is the first vehicle that you have in order to be able to give the Court of Appeals more insight into your case. There are a lot of things that judges and jurors did not hear or could have considered during the course of your case that they did not get to hear. The motion for a new trial is your first step in your ability in order to bring that to not only to the court's attention that actually heard your trial, but to also bring that to the Court of Appeals' attention in order to give them much more information to consider in order to give you the best chance of having your case reversed on appeal. Why is this important? Well, the way that I look at it is the post-conviction process is like a funnel. Your best chance of winning is at the top. This is where you have the most room and most ability in order to develop more information and put more stuff into the record, which gives you the best chance of potentially having a judge listen to the evidence that you've brought forward, whether it be regarding ineffective assistance of counsel or some sort of tampering that may have occurred or prosecutorial misconduct, whatever it may be. Any and all constitutional violations can go into this motion and be brought to the court's attention in order to give you the best chance right then and there. That judge can make a recommendation to say that I agree and that a motion for a new trial is granted because the court still has plenary power over your case, and that's something that can stop the entire proceeding from moving forward to the Court of Appeals to begin with. The best part about it is obviously that you have given your appellate lawyer much more tools and many more capable arguments to make on appeal if you were able to file that motion effectively, timely, and with all the information that could potentially give you much better outcome on appeal. In order to do that, you need to talk to somebody that's experienced, that has filed these motions before, that has been before a judge on an evidentiary hearing in order to be able to develop all of these issues, that understands the deadlines, that understands the importance of what needs to go into all of these motions, that is effective in being able to hire the right investigators or to themselves investigate the issues that they believe is most effective for your case in your situation. And if you do that, your chances become that much better. In the event that you find yourself in this type of place, and in the event that you have unfortunately found yourself in a place where you have been convicted of a crime, call me and let's talk about it. I will break everything down for you, and I will give you my opinion and my best assessment as to why you should move forward in the direction of filing a motion for a new trial.